The media won't tell you this, but the Trump birthright citizenship case isn't about changing the law. It's about restoring the Constitution's original meaning. The real question before the Supreme Court isn't just, should children of illegal immigrants be granted birthright citizenship? It's, will the court follow the original intent of the 14th Amendment or continue decades of judicial overreach? And today, we're using the only real authority on this issue, understanding the natural-born citizen clause, to set the record straight. If you care about the Constitution, buckle up. So what's actually happening? Here's what the media won't emphasize. The Trump administration has challenged birthright citizenship for children of illegal immigrants. They've appealed to the Supreme Court to block lower courts from overriding an executive order that enforces the 14th Amendment's original meaning. This case could permanently change how citizenship is determined in America. But more importantly, the question isn't new. It was already answered by the Founding Fathers and the framers of the 14th Amendment. And that's where this book comes in. Understanding the Natural-Born Citizen Clause is the most complete, in-depth analysis of what the Constitution actually says about citizenship, allegiance, and presidential eligibility. It is the controlling authority on this issue. If you haven't read this book yet, you're missing the full legal picture. And in this video, we're breaking it all down. Here's what matters. The 14th Amendment does not guarantee citizenship to every child born on U.S. soil. That's a lie. The full text says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. That phrase, subject to the jurisdiction thereof, is the most ignored part of the 14th Amendment. But according to the framers of the amendment, it's not redundant, it's restrictive. And here's proof straight from the historical record. Senator Jacob Howard, a co-author of the 14th Amendment, stated explicitly in 1866 that this clause does not include foreigners, aliens, or those born to foreign ministers. In plain English, if you don't owe full allegiance to the U.S. at birth, you don't automatically get citizenship. So what does this mean for today's case? The children of illegal immigrants are not subject to U.S. jurisdiction in the full legal sense, and therefore, they are not entitled to automatic citizenship. Trump's executive order isn't creating a new rule, it's restoring the real meaning of the 14th Amendment. But here's the real kicker. We already have Supreme Court precedent that backs this up, and the media refuses to talk about it. Let's talk about Elk v. Wilkins, 1884. Elk v. Wilkins was a Supreme Court case that ruled that being born on U.S. soil does not automatically make you a citizen. John Elk was born on American land, but was part of a Native American tribe. He later tried to claim U.S. citizenship. The Supreme Court ruled no, because he was born under the jurisdiction of his tribe, not the U.S., and had never fully submitted to U.S. jurisdiction. Why does this matter today? If someone born inside U.S. borders but with allegiance to another political entity isn't automatically a citizen, then neither are the children of illegal immigrants. Illegal immigrants have allegiance to their home country, not the U.S., just like John Elk had allegiance to his tribe. Elk v. Wilkins is the controlling precedent that the Supreme Court must follow. And guess what? This ruling has never been overturned. If the Supreme Court upholds birthright citizenship for illegal immigrants, they'd have to overturn their own ruling in Elk v. Wilkins. And if they do that, they'd be rewriting the Constitution, not interpreting it. Now, some people will bring up United States v. Wong Kim Ark, 1898, and say, wait, the Supreme Court ruled that children of foreign nationals born in the U.S. are citizens. But this is where people get it wrong. Wong Kim Ark's parents were legal, permanent residents of the U.S. They had fully submitted to U.S. jurisdiction. That means their son, born on U.S. soil, was correctly ruled a citizen. Why does this matter? Wong Kim Ark does not apply to illegal immigrants. It applies only to children of parents who have full legal allegiance to the U.S. People misuse this case to argue for universal birthright citizenship, but that was never the ruling. So don't let the media fool you. Elk v. Wilkins is the case that applies to illegal immigrants. Wong Kim Ark applies to permanent legal residents. This means the Supreme Court has one duty: follow precedent and rule in favor of Trump's executive order. So where does this leave us? The Supreme Court has a choice to make. Do they follow the Constitution's original meaning and the correct legal precedent? Or do they continue the decades-long judicial overreach that has distorted the 14th Amendment? If they rule correctly, Trump's executive order will stand. Birthright citizenship will be restored to its correct legal definition. Illegal immigration incentives will be eliminated. If they rule incorrectly, they will permanently rewrite the Constitution. They will create a loophole for foreign nationals to gain citizenship just by giving birth in the U.S. And they will destroy the founders' principles of national sovereignty. The correct ruling is obvious. And thanks to understanding the natural-born citizen clause, you now have the full, undeniable truth. This is the most important Supreme Court case in modern history. Get this message out there. Share this video. Get the facts straight. And most importantly, get a copy of this book. It is the controlling authority on the 14th Amendment, birthright citizenship, and presidential eligibility. Now let's hold the Supreme Court accountable.